Hello, everyone. Welcome to the last webinar of the year for the Carpenter Law Firm. I am happy to have you join me. I've got a few things to go over for the end of year recap and 2026 predictions. I don't know about you, but it seems amazing that we're talking about 2026. For those of us that have been doing this for a long time, it does seem amazing that we're talking about the year 2026. But then again, time flies, I guess, if you're having fun. But I guess that's the way the world works these days. Time flies. So let's talk about 2025 cases and 2026 predictions. When we talk about what happened in 2025, I'm talking about court cases. I am not going to go back over the 2025 legislature's shenanigans. This is not a legislative recap. I've already done that. If you want that, that webinar is on my website at www.carpenter.law. That's my website for all things Carpenter Law Firm. And this is not a legislative recap. I've done that. And so I'm happy for you to go there and receive that legislative summary. In short, the legislature was active again in 2025. The Arizona legislature meets every year. Some states, the legislature meets every 2 years, Texas being one of those. But in Arizona, we do it every year. It starts in January. And in a few weeks, the legislature will be back at it. And it's the nature of things in Arizona. We can set our annual clock with the idea that the legislature is going to do it again in January. So here we're going to go in a couple of weeks. So some of my predictions for 2026 will center on the legislature, but this is not a legislative recap. So 2025 cases. Cases from the courts. What has the courts done in 2025? So I'll start with that. Let's start with Callaway. When we talk about court cases are named for the litigants, the parties to the cases. Callaway being the one that we talk about since 2022. This is a Supreme Court case that we talk about here in Arizona, and it's also being talked about across the country because it was so controversial. Callaway is our Arizona Supreme Court case that held that adding a new covenant often requires a 100% vote of the owners. This was new. We didn't expect it. It was not a case that involved any of the usual suspects of community association lawyers here in Arizona. I did not handle it. I was not retained to be involved in it. The other regular community association law firms were not involved. It was a case handled by other lawyers. When a community association law issue comes up, there is no special requirement that those of us that devote our law practices to community association issues, there's no special requirement that we become involved. So that's what happened in Callaway versus Calabria Ranch, a case in Pima County. So it was decided that by the Supreme Court that adding a new covenant requires a 100% vote. That's the way the case reads, and that's how we interpret it. So that's the idea that has essentially escaped into the ether of community association law here in Arizona. And I get calls from lawyers across the country about how they should approach the case in their state. Will it bleed over? Will courts in other states adopt Callaway into the law of their jurisdiction? I'm not going to mention a state in particular, but as you can imagine, if you're a lawyer in another state and you hear a lecture on Callaway, It would change the way you think about doing CC&R amendments in your state. Just fill in the blank with any state. You'd be a little nervous that all of a sudden a court of appeals or a state Supreme Court in that other state might all of a sudden adopt the same rationale as Callaway. So in 2025, no court cases that were reported in the Law Reporter and published, there were no cases that cited the Callaway decision. That doesn't mean that there have not been cases making their way through the court system. My webinar in November went to some lengths to explain our court system. Cases start in trial courts. They may be appealed to the Court of Appeals and then may be appealed again to the state Supreme Court. What I didn't spend a lot of time on in November in that webinar is how cases are cited, CITED, and how they end up being published into those law reporters. In the old days, cases were published into leather-bound books, and they lined shelves of libraries and law offices. When I started as a lawyer years ago, it was pretty much mandatory that all law offices have a library, and they were expensive to maintain. In fact, it was the most expensive startup cost of a lawyer starting his or her own law firm was the cost of the library and the subscriptions to these case law books. And some lawyers still maintain subscriptions to these leather-bound case law books. When I started the Carpenter Law Firm in April 2024, it never even occurred to me to set up a library of actual physical books. It's all done online now, just like everything else in our modern business culture. There are two main online subscription services. Westlaw is the #1 publisher of these leather-bound books. It's also the #1 online provider of cases. The competitor is called Lexis, Lexis, sometimes called LexisNexis, and they provide free subscriptions to every law student in the country, get you addicted early. And they even did it when I was in law school back in the 90s. So it never occurred to me to have these leather-bound books. But publishing a case in these leather-bound books is what causes a case to be published for precedent, which I'll explain in a minute. So in 2025, there were no published cases that cited the Callaway case. There may be other cases making their way through the system, but there were no cases in 2025 that cited Callaway. Callaway being the most important case we've had in Arizona in many years. There were 2 cases in 2024 that cited Callaway. 3 court cases cited Callaway in 2023. One case stated, forgive my grammar, one case stated that removing a covenant does not require 100%. That case is called Thompson Thrift versus Albertson, but it was unpublished. It did not make its way into these leather-bound books. And it's actually a really important distinction. The idea that an opinion is published or not has to do with whether it can be cited, CITED, as precedent. And so we end up with this odd distinction where we know about the case, we can find it, we can send it around. I could email you the Thompson Thrift case, and I could send it to another lawyer and say, look at this case, look what it says about Callaway, but we cannot put it in a brief and say to a court, look what the Court of Appeals said about Callaway in the Thompson thrift case. It's a bit frustrating. So here's a comment about Callaway, just as an aside, even though I'm giving you the report about what happened in 2025, this is a footnote about Callaway. So remember that Callaway says that amending CC&Rs needs 100%. But here's my footnote. It is still possible to amend the CC&Rs at your amendment threshold. Let's say your amendment threshold in the documents is 75%. You could still do that in the sense that, the fifth grade kid goes up to the teacher and says, can I go to the bathroom? And the fifth grade teacher is feeling frustrated and snotty on that day and says, I don't know, can you? And the fifth grade kid says, I think my teacher's being toxic today because I said, can I go to the bathroom? And the teacher said, I don't know, can you? Well, I'm making that point. I'm being toxic about Callaway. Association says, can we still amend at 75%? And I'm kind of making the toxic point. I don't know, can you? Well, you can in the sense that you can go door to door and you can get to 75% yes votes. You can. If you can, you can. If you can do it, you can do it. And you could take those 75%, you've accumulated 75% yeses in this hypothetical, and you can attach those and you can record your amendment. The vote occurs, you record the amendment, and the association could move forward with that recorded amendment and take the position that Callaway, in air quotes, Callaway happens when an owner files a lawsuit. And we could ponder the academic question. Not all amendment topics are economically motivating for an owner to write a check for a lawsuit from his or her personal checking account. The vote happened, an amendment was recorded. The association moved forward. There was no lawsuit to challenge the amendment under Callaway. So what happened in this hypothetical? The CC&Rs exist. They have an amendment provision. We'll call it 75%. And in the recorded documents at the county recorder, in whichever one of the 15 counties in Arizona you want to ponder into this hypothetical, there are CC&Rs, there's an amendment provision, an amendment purportedly was approved, the amendment was recorded, no lawsuit was filed. What happened? No lawsuit, an amendment was recorded. Did it happen? Is it enforceable? Well, frankly, I don't know, folks. I don't know what a court would do years later. How many years does it take for that amendment to sit there and accrue validity before an owner could pick up the mantle of Callaway challenge years later? We don't know. We actually don't know the answer to that because Callaway hasn't been around long enough for an owner to challenge the amendment in this the hypothetical amendment on this slide has not been challenged 15 or 20 years later in this hypothetical to know whether or not this can happen with impunity. We just don't know. So what's happened with Calway, and again, I'm in a 2025 recap, 2026 forecast, and I'm deviating. I'm footnoting a bit about Calway, and I know that I'm going to get out of it here in a second. I'm going to escape. We can operate in fear of Calway or attempt a rational and balanced approach, and perhaps a written opinion from the association's attorney regarding the risks and costs of moving forward with an amendment with less than a 100% approval. If you move forward at 75%, can an attorney explain what I just explained and have the board say, yeah, we understand that. We'll go ahead at 75%. And if we record the amendment at 75%, we understand that an owner could file the lawsuit and may win under Calway, that it takes 100%, but an owner might not file a Calway lawsuit. And if they don't, then maybe we'll just do the amendment anyway. I don't know. Every association's different. Every board and community is different. Every Calway challenge is a little different. But right now, there's a somewhat systemic concern about Calway. But there are also a number of clients I've had who have said, we understand Calway. We also understand that our amendment threshold is 75%. But if nobody files a lawsuit, but we get 75% anyway, then maybe that's a risk we'll take. It reminds me of the riddle my dad used to ask me when I was a kid. Hey, Scott, if a tree falls in a forest and nobody hears it, does it make a sound? If an amendment is recorded at 75% and no one challenges it, is there a Calway problem? If my dad had been a lawyer, perhaps he would appreciate the attempted humor there in my analog to his riddle about if a tree falls in a forest and no one hears it, does it make a sound? I'm making myself laugh on the inside, thinking about my dad telling me that riddle when I was a kid. You may not find it all that funny, but I'm making myself laugh on the inside. All right, a note regarding precedent. You know, the word precedent is tossed around a lot in our world. What does precedent mean? The most common way that we use the word precedent in the community association industry, if you want to use the word, is, hey, if we allow that guy over there in lot 48 to have that RV in his driveway, then we're setting a precedent. And it's a bit of a misuse of the term. You'll see why I mean it's a misuse of the term. It's a misuse of the term in the way that I'm going to use it in this presentation. Certainly, it's a misuse of the technical legal way I'm going to use it. But it's probably a misuse of the term the way it's used in our industry. So let's start with the way it's used in our industry. Does it set a precedent for the association to tolerate Unit 48, Lot 48, having an RV in the driveway? Well, it's a problem. I don't know that it's setting a precedent. The reason it's a problem is because when you allow Lot 48 to have an open violation, other people who want to have the same violation will say to the association, hey, I want to have that violation too. I have an RV and I would rather have it in my driveway than spend $200 a month to have it down the road at the storage space. We've all heard it before. Having an open and obvious violation is a problem. You can use the word precedent, but it's actually a problem because it allows people to say, I want to repeat that. I want that violation. You're letting the lot 48 have the violation. I want it too. So we use the word precedent. What we really are doing by allowing lot 48 to have that violation is we're allowing people to say, I want it too. So the word precedent becomes a word for we're allowing it, but what it's doing is letting other people say, I want to copy it. So precedent's an okay word for that, but the technical legal word is somewhat different. So what do I mean? Well, in the legal world, precedent is a court ruling that matters for future court rulings. So here's what makes it tricky. If there's a ruling in a superior court case, remember, superior court is where trials and court cases originate. That's not small claims court. It's not justice court. It's our trial court for real cases that are not small claims court and not justice court. Significant disputes that originate in our trial courts here in Arizona. A ruling from a superior court judge is almost always online, at least in Maricopa County. It's online in the form of a PDF, portable document format, and can be obtained online. So we see this from time to time where an association is involved in a dispute, and the ruling from the court, which can sometimes be 1 page or 8 or 10 pages, can be downloaded in a PDF format and circulated. And I've had this happen where there was a case a couple of years ago about a group home where word circulated in our industry, if you want to use the term, that an association, here was the rumor mill. The rumor mill was that an association got an injunction against a group home. And the reason that that was so unbelievable is because federal law permits group homes to operate even if they're contrary to CC&Rs. Congregate living arrangements of people with disabilities are permitted under federal and state fair housing. So rumors were circulating that a court case had occurred where the association successfully enforced its CC&Rs against a group home. And then I heard the name of the association. Somehow it kind of, circled back. So I did the search of the court cases and I found the PDF of the court's ruling. And of course, it didn't say anything close to what the rumor mill suggested. There was a court case, there was a ruling, but it didn't say that the association could enforce its CC&Rs against the operation of a group home. So sometimes a superior court judge's ruling can be obtained online. Court of Appeals rulings can be obtained online as well. And in fact, you can subscribe via email subscription to receive every Court of Appeals ruling in your inbox. Division 1 and Division 2. Southern Arizona, Northern Arizona. There are 2 divisions of the Court of Appeals, and you can subscribe. I do. I get every Court of Appeals opinion in my inbox. But only published Court of Appeals decisions and Arizona Supreme Court decisions are precedent for the future of the common law. You can only go into court, whether it's justice court or superior court, or arguing a case before the Court of Appeals or the Supreme Court. If you represent yourself or if you're a lawyer, you can only cite CITE as precedent, a published decision. Now, in the old days, this was easy because they were literally published in those leather-bound books. Unpublished decisions literally did not make their way into the leather-bound books. Now, because everything's online, it's a notation at the top of the PDF opinion. And it literally says something to the effect of, not meant for publication. This is not published. Well, it is literally published in the sense that it's printed and it has a tracking number in the Westlaw system at westlaw.com. And it's published in the sense that if you go to the Court of Appeals website, you can obtain the ruling. And interestingly, the Thompson Thrift v. Albertson case, which I find fascinating because it said that when you remove a covenant, it doesn't take a 100% vote. It's unpublished, but you can get it. It's published in the Internet of 2025 sense. It's published to the internet. It's published online. It's a PDF. I can download it. In fact, I was having lunch with a lawyer friend of mine in Yuma earlier this week, last week, doesn't matter when. And we were talking about Callaway, and I mentioned the Thompson Thrift case, but it's unpublished. And so I sent it to him because it's a curiosity. There are limited circumstances under our lawyer rules of how to practice. There are limited circumstances where we're allowed to mention an unpublished case in court proceedings. Very limited circumstances. So I gave it to him. It's a curiosity. He represents some community associations in Yuma County. So we were, talking about the state of the law and whatnot. I was visiting with some clients in Yuma, and so we took the opportunity to have lunch. And so I sent him the case. He was unaware of it. Why would he be aware of it? It's unpublished. I mean, it's kind of a weird thing. It's good to know that the Court of Appeals is willing to see Callaway that way, but we cannot cite it as precedent for the future of the common law for how to resolve future disputes. But at least we know how the court saw that dispute. The common law is the law of the courts, can be cited in cases as binding on courts and judges in similar and future cases. So we understand what precedent means in the legal sense. The cases matter, but precedent in our community association vernacular and the way we think of it, and frankly, and I mean no insult, the way board members use the word is different, and we know that. We can appreciate the distinction. We're setting a precedent by allowing a violation and doing nothing about it. That's human nature. That's a teacher in a classroom of junior high kids or high schoolers who allows chewing gum, even though it's against the rules, and expecting that a month or two later they're going to be able to stop the chewing gum or whatever is against the rules. It's harder to get control back when you allow violations. It's human nature. The precedent of allowing violations and then thinking you're going to get control back. I mean, geez, you could say that about parenting. If you've been to my webinars before, I've mentioned I've raised three teenage daughters. You could say it about parenting. You could say it about trying to control a junior high or high school classroom. You could say it about being a professional community manager. It's hard to get it back once you've lost it. So I think we understand now what precedent means and what it means for an unpublished decision. And perhaps as a professional community manager, you've been involved in litigation where this has happened. But it matters to the client. It determines the outcome of that matter. All right, let's talk about 2026. I've been, and this is not bragging, this is trenches where I've been in my career. I've done a lot of volunteer lobbying on behalf of individual clients, on behalf of the industry, and I anticipate I'll do it again in 2026. My first foray into volunteer lobbying was, well, it dates me. I don't mean to make myself older than I am, but it was in the mid 90s. So here's what I think is going to happen in 2026. I've noticed that our thing is it's tied to the housing market, as we know. And it's not just about the fact that as the housing market is booming, there's more community associations. I don't mean to make that elementary observation, but I'm talking about existing community associations as well. A mature community association that's been around for a long time. Just think of an average fully mature community association in Central Phoenix, Central Scottsdale. Just think of any community association that's fully built out, Central Gilbert, Chandler, Tempe, it doesn't matter. If the housing market is booming, we're feeling good. A built out, mature, been around for 20 or 30 years community association, things are better if the housing market is booming because resales are happening, home values are up, and for reasons that are not always obvious, the association is doing better. New people coming in, energy is better. Our thing is feeling healthier and more robust. I think interest rates are the number one indicator of the health of the industry overall. Oddly, interest rates predict assessment delinquencies, maybe not so oddly in the sense that when interest rates go up, the economy slows down, which is purposeful. When the federal government increases interest rates and increases the cost of borrowing, it slows down business and commerce. When borrowing costs go up for businesses, it slows things down. And when the whole system slows down, assessment delinquencies go up. The job market suffers, at least in the short term. And we see, and I've been through a lot of up and down cycles in my career, the assessment delinquencies go up. And then people try to borrow to make up their delinquencies. And now the borrowing costs have gone up on their credit cards. It's a vicious kind of problem. As the interest rates go up, the economy slows down. They have trouble with their jobs. Now they've got trouble paying their delinquencies. And now the cost of borrowing money to pay off their assessment delinquency has now gone up. It's not so easy to just put the money on the credit card. And then the insidious problem they have, and I've been handling some with my colleagues here at the Carpenter Law Firm, we've been handling some delinquencies lately where we've had to give that same speech to people. Hey, we'll do a payment plan, but don't give us a payment plan number you can't keep. But the optimism is, hey, I'm going to keep my job and this is what I think I can afford. But then people lose their job in the midst of the payment plan, and then there's no way out. People would prefer to keep their home in a foreclosure, but they end up in a situation where optimistically they say, well, I'll pay $800 a month. Well, now we have legal fees on top of the assessments, the late charges, the management company charges, and now they're going to borrow money on a credit card, which is exorbitantly more expensive. But then they get fired because they've already have problems. So the interest rates being higher without any real indicator in the broader economy that the interest rates are ever going to get back down to 1% at the federal level or zero like they were a few years ago. There's just no indication that's going to happen, where mortgages are going to be down to 3% or 2.5%, whatever it was. I don't see it. Those were boom times. I'm not sure we're going to see again. Zillow Research suggests, just a resource I found online preparing for today, that mortgage rates will hold above 6%. Now, some people remember the early 80s when mortgage rates were in the teens, 12, 15, 16%. I was a kid. I don't remember that. I've asked my parents about it, and they sort of vaguely remember it. I lived in Dallas at the time. I was in, junior high, but I don't remember it as a full adult human. All the homes that I've bought have been below 10%. Since the mid 90s, and we've had ups and downs from that point forward, but 6% and above doesn't seem that bad for a lot of people, at least within the last 30 years. But we were spoiled there for a time, and so 6%, above 6% feels expensive comparatively to that period where people were refinancing below 3% or around 3%. So let's talk about the Arizona legislative session. I predict that in January, the legislative session will be active again for our thing. Why do I keep saying that? The HOA world, condominiums, planned communities, it's going to be active again. I believe all stakeholders will be looking for victories. The most active stakeholder is the group that claims to be representing the homeowner who is suffering under the suffering at the hand of the bad boards and management companies. So there are still whispers to eliminate HOAs. This has been in the news some. A legislator in Florida submitted a bill in the Florida legislature to eliminate all community associations in Florida. I don't practice in Florida. I'm not licensed in Florida. I have not taken the Florida bar exam. I have nothing to do with it. There is no bill in Arizona yet, but there are people who have talked about it. It is easy. Anybody can imagine a world where community associations do not exist. But every lawyer can imagine. There would have to be a community association lawyer. Every lawyer with a license to practice law can imagine the complexity of unwinding community associations that currently exist. The legal and logistical nightmare. It would keep the community association bar, and by that I mean the lawyers that currently represent community associations, those of us that do it in Arizona, let's say there's 50 of us, 60 or so, who knows that I don't want to add them up, but however many there are of us, it would keep us busy for decades with the legal costs borne by the homeowners, the unwinding, the dissolution and unwinding of just the planned communities. Forget about the condos. If you just wanted to unwind the planned communities, it would take decades and would cost in the millions of dollars in legal fees just to unwind the planned communities. And do what with the common area? Convey it to the municipalities or the counties? And I guarantee you, the municipalities and the counties do not want it. The legislature would have to solve that problem first. And whatever I'm saying about Arizona, because I've lived here and practiced here for over 30 years, I know that about Arizona culture. I know that about the attitude of the League of Cities and Towns. If I know that about Arizona, I suspect that the same would be true in Florida and Texas and California and every state in between, and that the logistical nightmare is the same and the attitude would be the same of those cities and towns and counties everywhere in between. It would never happen. Now, let's talk for just 10 seconds about condos. Other than terminating them, making everybody move out, and selling the land to investors after a wrecking ball tears it down, which would never happen. Other than that, there is no logistical way to unwind a condo and leave the building there with the people living there. What is it? What is the building that leaves people in the units owning the units if it's not a condominium? There's no substitute ownership structure that keeps it a condominium with shared ownership, shared assessments, shared maintenance responsibility. How do you dissolve the condo and rid the ownership structure of common ownership, common assessments, and mandatory ownership, mandatory membership, mandatory assessments? How do you get rid of all of that and replace it with something that's not that? I mean, the idea is an absurdity. So predictions are, there will still be whispers, but there is a way to erode governance and make community associations have to work harder for success, which we've seen a little bit of already in 2025 with this idea of owners versus boards. Give owners more rights with books and records, make open meetings more onerous, and already we saw in 2025 make it harder to collect assessments, restrict lien authority, and make it harder to enforce covenants. In other words, death by 1,000 cuts. We may not be explicitly eliminating HOAs. We may not do this, but we may kill you death by 1,000 cuts, which is why the 2025 legislative session was frustrating in a way. We're not going to eliminate HOAs. We're just going to continue to chip away at the authority of the association each time we can, each time we get a chance. So that's kind of where we are in terms of the prediction for 2026. I mentioned the stakeholders. Let me go back to that for a second. I wanted to be really clear about it. I'm sorry. I mentioned one stakeholder group, which is the homeowners that feel betrayed by the idea that it's good for them. They feel like they're picked on. HOAs are another stakeholder, and developers, real estate brokers, developers, home builders. There's a lot of stakeholder. When there's a stakeholder meeting and everybody gets in the room, it's a big group. And hopefully the legislature will continue on a promise made a number of years ago that bills will not move through the process without bills being vetted by the stakeholder process, where everybody gets in a room and the group has to run the bills through the stakeholder process, and the bills will move if the stakeholders approve them. Doesn't mean everybody gets what they want, but essentially the stakeholder process will vet the bills and then they'll move if the stakeholder process approves the process. So that's the predictions for 2026. No guarantees about what the legislature might do. I am concerned mostly about assessment collections and lien authority, not so much about covenant enforcement authority, but this governance problem, making it harder to govern, and owner versus board attitudes coming from legislators who are open to hearing stories from constituents and then saying, well, there ought to be a bill, there ought to be a law. And laws start with bills that make their way through the legislature. So we're going to keep an eye on it and do the best we can. All right. Any questions? We do this through the chat or Q&A. Hopefully I've covered it. I've had a little trouble with this in the past, but hopefully it's open. All right. Well, thanks for joining me on this last webinar of the year. Hopefully you have a good holiday season, and we'll see you again in 2020. It looks like I have a question. How does a homeowner participate more actively in lobbying efforts? It's a great question. I would get in contact with the local chapter of Community Associations Institute, CAI-AZ.org. That'd be a great place to start. Who decides if and when a ruling is published? Phenomenal question. The court itself, and this only applies to the Court of Appeals. All Supreme Court decisions are published. In this notion of being published, all Supreme Court decisions are published, I believe. The Court of Appeals is the only court that has unpublished decisions, and some of those Court of Appeals decisions are published. The court itself, the judges themselves, decide which decisions to designate for publishing. It's a great question. I've had a number of cases at the Court of Appeals where I have requested, after I received the ruling, I've filed a motion with the court that the court publish it, because I felt like the ruling touched on an important rule of law that would be important for future cases. So there is a way, once a decision is made that's not published, there is a way for the lawyers to request that it be published. if it touches on an important legal topic. Some lawyers request that it be published, some don't, but there is a way to do it. But sometimes not. So yeah, the judges themselves decide. All right, anything else? All right, thank you all for joining me. One more. Would a decision to eliminate an HOA be an ownership vote? We have done this in the past where we have done an amendment to remove the restrictions. Remember I said that this court case, Thompson Thrift, says removing restrictions doesn't require 100%. So we have had clients before where we have done an amendment to remove restrictions, which is essentially eliminating an HOA. Yes, it would take an amendment. So yes, to terminate an HOA would require an ownership vote in nearly 99% of the cases. So I would say yes. A decision to eliminate an HOA would take an ownership vote most of the time. All right, thank you all. Have a good holiday season, and we'll check in with you next year. Thanks. Bye.